state and the defense have come to an agreement in this case. I received complete paperwork from the parties. I'm going to go over with Mr. Meekings. Court will take notice of the content of the court's file, the record, and all of our prior proceedings. Go ahead and raise your right hand, sir. You swear affirm the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God. Put your hand out. Tell me your name. Are you indeed the defendant in this matter? Does the indictment reflect the correct spelling of your name? Can you speak, read, and write in the English language? All right, I've got documents here under this cause number that I believe will be introduced later in our hearing. The State's Exhibit 1 and State's Exhibit 2. They look like this. The content of this packet contains written waivers of important rights that you have. If you read the content of this packet, with the help of your attorney, you understand all that it says. Now, where it says defendant here, is this your signature? You're telling me you understand the rights contained within this packet. Here are some of these documents that you wish to waive certain rights, namely the right to trial by jury, the right to the appearance of, confrontation, cross-examination of the witnesses against you, the right to remain silent, the right to an appeal, and all of the rights mentioned in these waivers. Is that what you wish to do today? Additionally, there's a stipulation of evidence contained in this packet. The stipulation of evidence is a judicial confession of the offense charged in the indictment. Let me show it to you right here. Is this your signature in the stipulation of evidence? And by signing it, do you swear affirm that the stipulation of evidence is true and correct? The court will accept the written waivers. I will sign them all to show my approval. Are you a United States citizen? Despite your representation, you are. I must warn you that a plea of guilty can may result in your deportation, denial of admission, exclusion from this country under federal law. Do you still wish to proceed? Have you ever had any mental health problems? Are you currently under prescription medication? The indictment in your case charges you with the offense of injury to a child alleged to have been committed on May 26, 2022. I believe that there are 3 enhancement paragraphs. First reads on April 3rd, 2015, the defendant committed third-degree felony offense of failure to comply with sex offender registration with the previous conviction. This offense was filed under clause number 114-001516 in 114 District Court, Smith County, Texas. The defendant was finally convicted on February 25, 2016. The second enhancement paragraph reads, on July 30, 2015, the defendant committed the second-degree felony offense of burglary of a habitation. This offense was filed under clause number 114-001616 in 114 District Court, Smith County, Texas. And the defendant was finally convicted on February 25, 2016. Third enhancement paragraph reads, on October 4, 2015, the defendant committed the second-degree felony offense of burglary of a habitation. This offense was filed under clause number 114-164915 in 114 District Court, Smith County, Texas, and the defendant was finally convicted on February 25, 2016. I believe that this offense is a first-degree felony that is enhanced. I believe that the punishment range in this matter is not less than 25 years confinement.
I'm sorry to interrupt. I should have addressed this earlier because if we're moving forward, just to clarify things, I was going to amend it. This is one of these indictments that listed multiple felonies.
Yes.
They were not sequential. So it's actually 15 to life.
Okay.
He can only be enhanced once, Judge. Just the way it was worded, all 3 of them. So it is 15 to life.
That's correct. That's actually reflected in the record. Okay. I believe that the punishment range in this matter is not more than 99 years or life, but not less than 15 years confinement. I believe the stipulation contains, appears to be stipulated to all 3 enhancements. Is that correct, Mr. Mills?
That's correct.
Okay. All right. Mr. Meekings, do you understand the language of the indictment as well as the punishment range?
Yes, sir.
All right. Do you believe that the attorney representing you has fully investigated your case, and are you satisfied with his advice?
Yes, sir.
All right. Mr. Mills, are you satisfied your client understands his rights, is competent, is prepared to enter a plea to this charge?
Yes, he does.
And you believe he understands the consequences of entering a plea of guilt?
Yes, sir.
That being the case, formally with the charge of injury to a child, as alleged by the state in the indictment against you, that charge, Mr. Meekings, how do you plead, guilty or not guilty?
Yes.
And to the first enhancement paragraph that I read into the record, how do you believe that enhancement, is it true or not true? The second enhancement paragraph that I read into the record, how do you believe that enhancement, true or not true? The third enhancement paragraph that I read into the record, how do you believe that paragraph, true or not true? Has anyone promised you anything other than plea bargain to get you to plead guilty and true? Has anyone threatened you, forced you, done anything unlawful to you to get you to plead guilty and true in this case? Are you pleading guilty because you are guilty and for no other reason? I will find your present competent to stand trial. I'll find your plea of guilt as well as true. It has been made freely, knowingly, and intelligently before your will, except for plea of guilt as well as plea of truth. State, do you have any evidence?
State of office marked the state's exhibit number 1, the plea packet, state's exhibit number 2, the written stipulation of evidence, waivers, some of the defendant and his attorney, attached exhibit A, the 3914 parts for Judge Taylor knows. All of the supplements, discovery-wise, we've done on this case, we've attached there to that 3914 compliance form, just for the record, that way everything's documented.
Court will admit states exhibit 1, states exhibit 2, all take notice of them. For the record, state what is the agreement of parties?
Your Honor, the agreement is for 40 years confinement in the Texas Department of Corrections. In addition, Your Honor, the court will be moving to 1245, consider cause number 475-0317-23, which is pending unlawful possession of firearm by a felon. We will also be moving to outright dismiss 475-031923, and finally, as reflected on the paperwork, there's the potential for another unlawful possession of firearm by a felon case, Your Honor. It came through in an interview. We will not be prosecuting for that particular case. I believe the date of offense would be around May 30th of 2022. That is the agreement in this particular case.
That's great. Mr. Meekings, is that also your understanding what the state would recommend what you have agreed to? With regard to 475-031723, I believe that is charge of unlawful possession of firearm by a felon. You admit your culpability in that matter. Court will receive the admission of culpability. I will dismiss it pursuant to Article 1245 Texas Penal Code. State, has there been victim notification in this matter?
Yes, Your Honor. We have spoken to the victim's family. They're in attendance today. Numerous discussions along these things. Agreement with this disposition. That these are things they would like to see happen as well. We have met all our obligations as far as.
And state, do you believe that this is in the interest of justice?
I do, Your Honor.
I don't think I've asked you. The parties waive the pre-sentence investigation report.
State waive, Your Honor.
All right. For the record, the court will follow the agreement of the parties. The court finds that the defendant has entered his plea in this matter voluntarily. The defendant was competent to make such a plea. There's sufficient evidence contained in the stipulation of evidence to support the defendant's plea to find the defendant guilty of the offense of injury to a child beyond a reasonable doubt in accordance with the plea agreement. And the court will also find the enhancement paragraphs to be true. In accordance with the plea agreement, the court now finds the defendant guilty of that offense, and I will assess his sentence at 40 years confinement in the Texas Department of Criminal Justice Institutional Division. There will be no fine. He will be responsible for costs of court and all other fees required for the law. The court will give him credit for any time he's already been incarcerated in our jail, and he will get time credit for whatever the Texas Department of Criminal Justice gives him. Is there anything else from the state? Anything else from Mr. Mills? That sentence is formally pronounced. Mr. Meekings, go ahead and see the bailiff. He's going to get your fingerprint. Good luck, sir. Thank you. We're in recess.